When I lived in the southern United States after college, but before law school, people told me that my dating options would be limited. I was 22 years old and apparently a spinster, so they cautioned that my dating market would probably be people who'd married young, were winding their way through a divorce, and just getting back into dating. I wasn't particularly interested in being a stepmother and ultimately didn't seriously date while I was living there. From friends and colleagues, though, I gathered how difficult it was to date as a parent. I listened as women agonized over whether their child was old enough to meet their new beau, whether they'd been dating long enough, whether there were any red flags they might have missed. It was an exercise in exhaustion and concern, a leap of faith. In the case of Sergeant Adams and his wife, it was a leap of faith that did not work out. There's nothing to suggest that Mrs. Adams somehow missed something, but everything to suggest that Sergeant Adams really sucked. This is Conduct Unbecoming. I'm Erin, and I'm your host. This episode covers crimes perpetrated against children and discusses sexual violence. I do cover some details of that violence, and it would be wildly inaccurate to assume that this topic won't be upsetting for some listeners. So please make the choices that are right for you. If that means that this episode is not for you, all good. In September 2012, the Army preferred a whole host of child sex offenses against Sergeant Thomas M. Adams for the crimes he perpetrated against both his stepdaughter and his niece, both minors at the time of their abuses. The government alleged that Adams was sexually abusing his stepdaughter when she was between the ages of 9 and 10 years old, when she was in the 3rd and 4th grade and living aboard Fort Riley. An investigation revealed that Adams showed his young stepdaughter pornographic images on his computer, asking her if she'd yet learned anything about sex in school. She described Adams telling her to take her pants off and to use her fingers and sex toys to touch herself. His stepdaughter didn't disclose to another adult what happened, fearing she would get in trouble. Adams told her these meetings would be their secret. To coerce his stepdaughter into complying, he threatened to tell her mother that she'd not listened to his instructions. She feared that if he did that, she'd be grounded or have her privileges taken away. During another incident at horse stables aboard Fort Riley, Adams directed his stepdaughter to remove her shirt so he could see her breasts, or whatever he thought constituted breasts at 10 years old. In the midst of yet another visit to the horse stables, Adams exposed his penis to the child, asking her to touch him. She refused. In their most upsetting and graphic encounter, Adams sodomized his stepdaughter in their home, stopping only when he heard a car pulling into the driveway. Adams's niece described similar abuses she endured at the age of 13 years old. Abuse that again involved a sex toy, rape, and requests for oral sex and child abuse materials. She also described a scenario in which she believed Adams took a photo while penetrating her. She described seeing a flash and reported that he told her he wanted to take a picture of himself inside of her while she was on top of him. Any resulting photo was not introduced into evidence, and the niece didn't describe seeing any resulting photo. Law enforcement seized 23 digital devices from Adams's home when they worked up the case, sifting through the data on them, but they either didn't find or just didn't introduce that photo. From what I gather, 3 other children came forward and made similar allegations, but we don't really have the details of those claims. As best I can put together, by the time Adams went to court-martial, his victims were adults. The panel found Adams guilty of 1 specification of carnal knowledge, 2 specifications of sodomy with a child, 7 specifications of indecent liberties with a child, 2 specifications of aggravated sexual assault of a child, aggravated sexual abuse of a child, rape of a child, indecent conduct with a child, 2 specifications of aggravated sexual contact with a child, producing child sexual abuse materials, possessing child sexual abuse materials, and possessing child erotica. Well, technically, they convicted him for producing and possessing what they called child pornography, but pornography implies some level of consent to its production, so I've updated the nomenclature to our preferred wording. Consistent with those convictions, the panel sentenced Adams to confinement for life with eligibility for parole, forfeiture of all pay and allowances, reduction from E5 to E1, and a dishonorable discharge. And if you're thinking to yourself, we're less than 10 minutes into this episode, and how are we already through the fact section? It's because the vast majority of this case happened after a conviction. So I think it makes sense to keep everything lumped together in one big segment today. The original conviction was in 2013, and on direct appeal, the Army Court of Criminal Appeals was compelled to conclude that there was a Hills error in instructing the panel. The United States v. Hills, a CAF case, held that charged misconduct could not be used as propensity evidence of other charged misconduct. There is a lot of discourse around the Hills decision, and without devoting significantly more time than I have available, I don't feel particularly ready to wade into that particular legal conflict. I do find it all very interesting to learn about, but I also don't feel read up enough to offer my take, and if that bums you out, I'm happy to share that there are a number of legal journals that analyze the matter. But as a high-level summary, CAF concluded that instructing the panel that they could use 1 incident of charged misconduct as propensity evidence for other charged misconduct was a constitutional error and could only be overcome on appeal if the error was harmless beyond a reasonable doubt. They had decided that the problem was that using charged conduct as propensity evidence was antithetical to the presumption of innocence, in that at the court-martial, an accused was presumed innocent of both incidents of charged misconduct, so using A as propensity evidence of B was problematic. And if you've been listening for a while, that might also sort of call into question the issue of uncharged misconduct. While Hills dealt with Military Rule of Evidence 413, Adams's case dealt with Military Rule of Evidence 414. Rule 414 here would govern the use of uncharged child molestation as propensity evidence. Among other instructions to the panel, the judge explained that each offense must stand on its own, and proof of one offense carries no inference that the accused is guilty of any other offense. In other words, proof of one act of child molestation creates no inference that the accused is guilty of any other act of child molestation. However, it may demonstrate that the accused has a propensity to commit that kind of offense. The ACCA compared the instructions that the military judge gave in Hills with the totality of the instructions the military judge gave to Adams's panel and concluded they were a bit too similar. The ACCA described the instructions as just as muddled and potentially confusing with respect to the burden of proof. Given that burden shifting and the resulting constitutional dimension, the court had to determine how harmful the prejudicial error was, or if it was harmless beyond a reasonable doubt. They couldn't get over that hurdle, so in 2017, 4 years after his conviction, they set aside the judgment and ordered a rehearing. While that retrial was pending, Adams petitioned the ACCA to issue a writ of mandamus and a writ of habeas corpus. He asked the court to terminate his court-martial and release him from pretrial confinement, asserting that the court-martial was barred by the double jeopardy clause and that the court-martial lacked jurisdiction over the charges. Substantively, the court-martial brought the same charges against Adams that he'd previously been convicted of, although some of the original charges were dismissed and brought again with more specific, or I guess more accurate, dates. Then the government added new charges. It was those charges that Adams moved to dismiss for lack of jurisdiction, arguing the convening authority exceeded the mandate of the ACCA's remand. The ACCA was unpersuaded by either of his writ petition arguments, concluding Adams failed to seek dismissal on double jeopardy grounds in the court-martial and that the government had not exceeded the scope of the remand for rehearing because, among other reasons, case law supported the referral of new charges with old charges, and an authorized rehearing returned the case to the convening authority to conduct a court-martial subject to the rules governing speedy trial, double jeopardy, unreasonable multiplication, and any other court-martial rules. If the convening authority could bring new charges that were consistent with all of those rules and obligations, there was really nothing in the case law to bar them from doing just that. So the ACCA told Adams to pound sand. A court-martial again convicted Adams for his multiple sexual assaults and the abuse of his minor stepdaughter and niece, although on the second pass Adams opted for a bench trial, not a panel. The military judge convicted Adams of 1 specification of aggravated sexual assault of a child, 6 specifications of indecent liberties with a child, 1 specification of indecent acts with a child, 1 specification of production of child sexual abuse materials, 1 specification of sodomy, 1 specification of aggravated sexual abuse of a child, and 1 specification of abusive sexual contact with a child. I think it's relevant to highlight here, he was charged and convicted for taking that picture with his niece. But Adams was found not guilty of charges that related to his stepdaughter, his niece, and those 3 other children that I mentioned earlier. He was acquitted of 1 specification of aggravated sexual abuse of a child, 2 specifications of sodomy of a child, 3 specifications of aggravated sexual assault of a child, 2 specifications of abusive sexual contact of a child, 2 specifications of indecent acts with a child, and 1 specification of possession of child sexual abuse materials. The reason I highlighted that he was charged and convicted for the production of child sexual abuse materials is because I also wanted to highlight that he was acquitted of the possession of child sexual abuse materials. So, Adams was convicted for taking the photo, but not convicted for possessing the photo. I do think it's really interesting that none of the charges related to the other 3 alleged victims stuck, and wonder if there's something to be said about the passage of time and the willingness of victims to return for a second trial. Given the totality of his convictions, Adams's maximum exposure was a sentence of life plus 123 years of confinement. The judge sentenced Adams to confinement for 43 years, total forfeiture of all pay and allowances, reduction again from E5 to E1, and a dishonorable discharge. The case returned to the ACCA, where Adams again challenged whether the court-martial had jurisdiction over the offenses and whether his court-martial was barred for double jeopardy reason. He asserted that the statute of limitations had expired for some of the specifications and that each of his convictions were legally and factually insufficient. The 2020 opinion from the ACCA is a very interesting legal read as far as the statute of limitations goes, because of the deep dive it takes into congressional intent behind revised statutes of limitations and what constitutes child abuse or sexual abuse. I recognize that it is not a discussion that is riveting to everyone, but I want to highlight that the ACCA concluded that given the legislative history, they believed this hyper-specific scenario to be, quote, one of those rare and exceptional circumstances where the application of the statute as written would produce a result demonstrably at odds with the intentions of its drafters. So the ACCA took what it described as a common-sense approach, intending to avoid an absurd result. The 2016 revision that they focused on seemed to limit the statute of limitations as to certain sex crimes. And I think the common sense approach that the ACCA took, which resulted in the conclusion that the 2016 amendments did not shorten the statute of limitations as to the crimes charged here, makes sense. From the 10,000-foot view, it's not consistent with historical trends to shorten the statute of limitations on sex crimes, let alone sex crimes committed against minors. It took a lot of legal writing to get there, and if it sounds like that might be of specific interest to you, the opinion is linked in the show notes. Adams made a few other arguments that the court disposed of in a footnote, finding they neither merited discussion nor relief. The ACCA determined that all of the convictions, with the exception of the production of child sexual abuse materials, were in fact both legally and factually sufficient. Even though the niece testified that Adams told her he wanted to take a picture of a specific sex act, committed that specific sex act, and she saw the flash of a photograph, there wasn't any evidence or testimony to confirm that a photo was successfully taken or just what was contained in the four corners of that supposed photo. But this feels like it's a little bit on shaky grounds. When we returned to the United States after living in Japan, our phones informed us that we could now turn off the camera shutter sound. Apparently, the audio cue is required on devices in Japan and not here in the United States. Reading this opinion from the ACCA, I did wonder if the shutter sound would be the tipping point in this fact pattern, but there's really no way to know. Because no photo was introduced and the niece couldn't testify that she saw the resulting photo, and that it qualified as child sexual abuse materials, the ACCA set aside and dismissed the conviction for production, and reassessed the sentence accordingly. Given his maximum exposure and the gravamen of his convictions, he still received a sentence of 43 years confinement, total forfeiture, reduction to E1, and a dishonorable discharge, which is the same sentence he received the first time. Adams marched on to the Court of Appeal for the Armed Forces, asserting in his appeal that the statute of limitations expired as to the charge for sodomy of a child under the age of 12 and some of the indecent liberties with the child specifications. CAF evaluated whether the 2012 charges survived being dismissed and re-preferred. The government urged CAF to uphold the convictions, arguing the charges were not time-barred because of the savings clause of UCMJ Article 43, Subdivision G. CAF rejected their argument, concluding that the statute of limitations for the indecent liberties and sodomy was reduced to 5 years by the plain text of the revised Article 43. CAF also concluded that the charges were not swept into redemption by the savings clause, rejecting the ACCA's common sense approach because the original charges were not dismissed because they were defective or insufficient. The court specifically rejected the government's argument that the previous charges, the charges with supposedly less accurate dates, were deficient and dismissed to bring more accurate charges, in part because not all of the date ranges were actually amended in the second filings. I think the takeaway message, then, is that dismissing charges following a remand for rehearing should be very, very carefully considered and completed. With those findings and conclusions, CAF doled out some additional relief, reversing the ACCA as to Charge 2, Specifications 2, 3, 4, and 5, and Charge 4, Specification 1. Those findings were set aside and the charges dismissed. The court returned the matter to the ACCA to either reassess the sentence or order a rehearing. From what I gather, the ACCA declined to reassess the sentence themselves and again remanded the matter, this time for just a sentence rehearing. In May 2022, a military judge sentenced Adams to confinement for 260 months, which is just over 21 and a half years, reduction to E1, and a dishonorable discharge. This now kind of radioactive case again came before the ACCA, who denied further review and affirmed the sentence. Adams petitioned the ACCA for a rehearing, telling them that they got it wrong when they denied him further review. His petition for a rehearing was also denied. Then CAF denied further review. At some kind of unspecified point in all of this, Adams alleged that the government violated his rights under Rule 707 because it took 192 days to arraign him in 2018 and should have taken probably just 120. On December 18, 2024, 12 years after the government brought charges against Adams, he was finally discharged from the Army. Well, I guess that depends on who you ask. Adams, for his part, maintains that he was not appropriately discharged because his appeal was somehow incomplete. So Adams next brought his matter to the Supreme Court of the United States in February of 2025 last year, arguing that CAF was required to review his claim of a Rule 707 violation. The Supreme Court of the United States, which is tied up with an emergency docket you can learn a lot more about on the Amicus podcast from Slate or the Strict Scrutiny podcast from Crooked Media, denied his petition in June 2025. And if you thought, Aaron, oh my God, this is too much, this case is dragging on, the women this man assaulted as children are in their 30s now, surely the Supreme Court of the United States denying his petition is the end, well, you would be mistaken. 11 days after the Supreme Court of the United States denied his petition for writ of cert, Adams filed an additional writ of habeas corpus in the ACCA, again raising a Rule 707 clock issue, which the court dismissed for lack of jurisdiction. He appealed that decision to CAF, asking the question of whether the ACCA lacked jurisdiction to entertain his writ. He hoped that CAF would say no, they didn't lack jurisdiction, and would remand the case to the ACCA for a review of the merits of his petition. But CAF agreed with the government that neither they nor the ACCA had jurisdiction anymore, because his punitive discharge had already been completed. He'd already been kicked out of the Army. The government covered all their bases and offered two explanations regarding the finality of his case. It was either the date of his discharge in December 2024 or the date that the Supreme Court of the United States told him it was the end of the road in June 2025. Although they didn't really need to decide between those two dates, because either way they predated the petition to the ACCA, CAF didn't equivocate and determined that the December discharge finalized his case as relevant to the ACCA and CAF. But then CAF left some breadcrumb suggestions to Congress on how they may wish to redefine finality, citing a historical and now eliminated rule that barred the Supreme Court of the United States from reviewing a case if CAF denied review. I don't anticipate a particularly rapid response. For what it's worth, in their 2025 decision, CAF highlighted a much more sympathetic writ of habeas corpus, a writ petition alleging ineffective assistance of counsel during a murder trial, and the denial of due process. A writ they also could not entertain because their jurisdiction had already terminated when the proceedings were finalized. Some would probably believe that Adams, who was arraigned at most 72 days late, was less sympathetic. And I'm wishy-washy on those 72 days because we don't know if there was excludable delay that people just hadn't fought about because it wasn't contested. But I do think it's safe to say at most 72 days late. I know that CAF's official position is that this case is finally, at last, stick a fork in it, done, if not overdone. But I can't say with confidence that we won't see more from Adams. He seems overly fond of filings and has a real penchant for petitions. I can't promise to cover further petitions because, frankly, it's hard enough to find information on someone with a name as common as Thomas Adams, and I'm not sure we want to dive into another can of worms from him. Thank you for listening. If you enjoyed today's episode, please take a moment to rate the podcast wherever you listen. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com or on conductunbecomingpod.com. Join me next time when we dive into a class of Air Force cases CAF tackled together. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, authorized, or endorsed by the Department of Defense, or by their new preferred name, the Department of War.